All right, thanks everybody. Welcome you back for our last panel of the day, titled All the Laws But Some, Why Do Agencies Not Enforce Laws? In case it's not obvious, it's a ham-fisted attempt to invoke Lincoln, his reference in his address to Congress in July of 1861 about habeas corpus and enforcing all the laws but one. This has been an interesting subject in the last few years. Agency discretion and enforcement discretion and non-enforcement obviously is nothing new. It goes, well back to Heckler versus Cheney and well beyond that. But in recent years, it took on much more political heat, I think it's safe to say. Virginia raised her eyebrows. Took on some more political heat on issues involving immigration, controlled substances, and so on. And so it's a great pleasure to put this panel together, in part because we have a very great paper, a new paper from Aaron on this, but also we're joined by two real experts in the field. And so with that, let's begin. Aaron, by being on this conference, speaking twice on this conference, makes my job of introducing him much simpler. Just think back to what I told you all this morning. It's still true. If you need a reminder, he's an associate professor of law at Brigham Young University Law School, where he writes and teaches on administrative law, civil procedure, federal courts, and antitrust. Like I said, my opinion on him from this morning hasn't changed. I still recommend that you read his indispensable blog posts at the Yale Journal on Regulation. He's going to kick things off today by discussing his new paper, How Agencies Choose Whether to Enforce the Law, Preliminary Investigation. It draws in part from and builds upon a major report he recently wrote from the Administrative Conference of the United States. And before Aaron takes over, I just want to say that ACUS is doing really tremendous work right now. The vice chairman, Matt Wagner, he was in the office. I think he stepped out. But I encourage you, to the extent you're interested in these issues or administrative law in general, be sure to take a look at what ACUS is doing right now. The work is really, really important and timely and interesting. And with that, I'll turn it over to Aaron.
All right. So I apologize to everybody that you get 2 doses of me today. I think they're thinking, this is the theory, I think they think, if we're going to fly him from Utah, we're going to make him speak twice. So with that, you're going to see another dose, and you're going to see another PowerPoint. I like to do this PowerPoint because I don't need notes that way.
You're also running coat check afterwards.
That's right. Yeah. I'll get cabs for you as well. It's all going to work. So here we go. Just as a quick preliminary, I'm glad that we have this panel because I come at this is close to what I write about, but not exactly the same. So a lot of this paper has been me learning as I'm writing. And as I was going through this, I kept reading all this stuff from Zach Price. And I'm like, is there a paper about this he's not already written? So I'm excited to hear what he has to say next, and of course from Virginia, who has a lot of very, very real-world experience about it. So here we go. Let's get started. When we think about agencies and administrative law, we often think of things they do to make sure the law is followed. So enforcement actions or other sorts of affirmative acts by agencies. I talked earlier about the City of Arlington dissent. The Chief Justice in that dissent also spoke on this, where he talks about hundreds of federal agencies poking into every nook and cranny of daily life. Tell us what you really think, Chief Justice. But that's kind of what we think about, and that's what a lot of our conversation today has been: affirmative acts by agencies to enforce the law. But in recent years, one of the big questions are agency decisions to not enforce the law. So here is the cert petition, or the cert grant in the Texas litigation. This was the immigration litigation from a few years ago, where the court, sua sponte, nobody even asked for it, hadn't been briefed before, ordered the parties to address the take care clause in their briefing. That is a remarkable order. I'm sure it's happened before where they have sua sponte inserted a constitutional question at the cert stage, but I can't remember that. I can't remember such a thing. Of course, then the court decided 4-4, so we got no opinion on the subject. But what a remarkable act by the court. Adam also spoke about drug policy. Recently, maybe you've noticed, especially if you walk around Washington, D.C., there's a smell. What is this? There's a federal law on the books. This is not consistent with federal law. But nonetheless, marijuana legalization in states and in the district. And how is this happening? This is happening by non-enforcement. There's a memo from the Department of Justice saying this is how we're going to prioritize enforcement, and if you have XYZ requirements, we will treat it differently. That's some controversy. There was a litigation that didn't really go anywhere between some states where they tried to bring an original action against Colorado for the spillover effects of the marijuana industry. Likewise, the Affordable Care Act. The Affordable Care Act, the rollout didn't go as well as folks had hoped. And there were a number of times where they said, here are things in the law that we're supposed to be enforcing, but in order to make this thing work, we're going to kick it down the road, and we're not going to enforce it. This was in the New England Journal of Medicine, of all places, talking about the legality of some of these decisions not to enforce provisions of the Affordable Care Act. Finally, this was from before the election. Josh Blackman had said, hey, what about hypothetical President Rick Perry? He says, you know what, I can't get tax reform done, so I'm just going to just do it. I'm going to say that the tax rate is 20% or 17%, and I'm just going to do it. I'm not going to collect. What are they going to do? You got a pushback here from Walter Dellinger saying, wait a minute, you'd still be on the hook for that. And that's surely true, though I just wonder what would happen if in year one of an administration they say we're not going to collect certain taxes, and then 4 or 5 years later, or 9 years later, a new administration comes in and says, hey, we're going to go back and collect that. I think we might have pitchforks and torches. I don't know how that would really work in practice. All of these are questions that are coming up in the non-enforcement space. Zach's going to give us a little bit of conversation on take care clause kind of stuff. But my purpose in this report isn't to necessarily solve these big picture constitutional type questions, but instead to really understand how this kind of works in the day-to-day reality of the agencies. So here's the dilemma. On one hand, non-enforcement can be problematic. I'm creating a case from the DC Circuit where they say the criteria used to make waiver determinations are essential because if they're opaque, the danger of arbitrariness or worse is increased. Complainants the agency likes can be excused, while difficult complainants can find themselves drawing a short straw. So if there's a whole bunch of prohibitions and they're only enforcing them sometimes, well, that gives the agencies a lot of leverage, and that can be a dangerous thing. On the other hand, what are you going to do about it? There's very good reasons for non-enforcement. One is just practical reality. There's no way to enforce the law all the time. There's just too much. There's too much law, there's too many violations, and especially if you consider investigations to figure out whether a violation has occurred, in theory that could be an infinite use of resources because you're searching to prove a negative. Was the law violated? Well, you can always keep looking to see. So there's resource constraints, and even beyond that, sometimes there are good reasons that we don't want enforcement. The law on the books, either a regulation or a statute, is designed to apply to a certain situation. No one really thought of a new situation that comes up, and we're like, well, wait a minute, we certainly don't want to apply it there. An example would be, nobody thinks you should take knives to school. On the other hand, there's a world of difference between a switchblade and when a kid brings like a kitchen knife to cut a birthday cake. Sometimes we say, wait a minute, it doesn't make sense to bring down the full weight of the law against all violations the same way. So too in the regulatory context. So what are you supposed to do? So I decided, as part of this ACUS investigation, to figure out how this actually works in the real world. For here, I'm going to focus on two findings, some empirical data about how certain agencies do this, and then a proposed safeguard to prevent abuse. So let's start with the data. The agencies that I met with, here are these 9. These are either through surveys or through interviews, and sometimes both. It's a lot in the Department of Transportation, for which I'm very grateful that they were so willing to meet with me. But we had a pretty good group, a pretty good mix here. We have the CFPB, we have the FAA, we have mine safety, we have a in the Treasury. There's a grant agency that provides grants. So a pretty good chunk of agency, good cross-section. And here's some things that we found. One finding is that agency vocabulary varies widely in this conversation. So I was tasked with waivers, exemptions, and I would ask people, what's the difference between a waiver and exemption? And they were all over the map on that. So I said, well, how does it look in the statute book? Maybe Congress is consistent. No, they're all over the map on that as well. So here we have one is an exemption is if it's this is for transportation. If the Secretary finds that the electronic charts are not necessary for the safe navigation of a vessel in the waters, then it's an exemption. If it's a waiver, if it's a whole bunch of ships or a very big water, okay, I guess I kind of see that. Then I say, well, what do we have over here in another Department of Transportation? It's all about time. If it's really short, it's a waiver. If it's longer, it's that doesn't even. That doesn't sync. It's not the same theory. So one thing, we all are using these words all of the time. Ask the other person what they mean by those words, because I don't know if we're using the words in the same way. More substantively, agency practices vary widely. The FAA has had 16,000 requests for non-enforcement as to drones. That's a lot. By contrast, the CFPB, they have two formal programs for non-enforcement. One is a trial disclosure where you can try new disclosure language and they can allow you to experiment. That's been on the books. They went to notice and comment rulemaking to create this program. They advertise it. They ask people to do it. It has never been used. It's been on the books for, I believe, 4 years. Never been used. No one's ever used it. It's not that they've asked for it and been denied. Nobody has even asked. They also have a no action letter program. When I initially started writing the report, that also never been used. Now it's been used once. So you compare, the FAA is doing this 16,000 times just for one part of what they do. CFPB is essentially never doing it. In terms of transparency, big differences. The mine safety folks have a very, very transparent process, partly because they only do 65 of these things. But it's all on a docket. You can see the comments. They open it up for comments. They have a report that goes through that kind of process, all very, very public. By contrast, the TTB, almost none of it is open. Why? Because it's taxes. And they're very, very wary of turning over that kind of data to folks. So very, very private. So you got massive transparency in one and not so much in another. Percents. Almost all of the agencies require a request, but the numbers of grant rates vary very markedly across the agencies. Some are essentially 100%, some are 36%, and even at 36%, it's hard to know too much what that means because sometimes it just takes so long that they just kind of withdraw the request. So but some common denominators are, at least when it comes to prospective non-enforcement, so leaving aside prosecutorial discretion, agencies rarely act without a request. I think that is useful for us to know. Most of the time when non-enforcement is happening, it's because somebody has asked. Likewise, at least when it comes to individual decisions, if they have a big, for an industry or something, folks outside of the agency might play a part. But generally, it's all happening within the agency. This isn't like the White House is coming in saying this is how to do this. It's really happening within the agency itself. And finally, which I also think I anecdotally suspected to be the case, I have found it to be the case, there's almost no judicial review of any of this. The FAA, who does thousands of these things, I said, well, does anybody ever sue? And they said, well, we can remember one time when somebody sued, and that case didn't even make it to final judgment. So there's a whole bunch of interesting things happening, all without a lot of judicial review. Some of that is because of Heckler v. Cheney. There's presumptions for at least an enforcement action that there isn't going to be judicial review of that. It can be rebutted, but very rarely. But some of these other things, which even could be subject to judicial review, almost never are, which I thought was interesting as well. So here's my proposed safeguard. And it comes again from the DC Circuit. My thought is, as a general rule, I realize there could be exceptions to this rule, but we ought to try to keep non-enforcement special. You should keep it. It should be a tool available to agencies, but it shouldn't be the default. It shouldn't be the sort of thing that you kind of build into the system unless you absolutely have to. Nuclear power or something, sure, maybe that makes a little bit of sense where you're going to overly regulate and then make people affirmatively show that they can get into the system. But often that's not really the case. So what you ought to do, it seems to me, is to, as far as possible, write rules such that it's only capturing the things that's actually dangerous. And if it's not dangerous, you shouldn't have to ask permission to do something, but rather you should be allowed just to do it. Here's the takeaway. It seems to me that when agencies find themselves receiving a lot of requests for non-enforcement and they're granting them, that's fine, keep granting them, but you really ought to, at that point, your brain should be thinking, wait a minute, maybe it's time for retrospective review. If we're granting these requests all of the time, maybe we don't want to have a system where people have to beg us for permission to act, but instead let's just prospectively change the law for everybody and just make it cleaner for the world. I think that would go a long ways towards cleaning up some of the problems. A few other thoughts, to the extent possible, of course, aim for transparency. If you can't be transparent about outcomes, you can at least be transparent about procedures. People should be able to find the law on this. They should have a sense for whether or not the agency is allowing this or not. So you have just a sense. I'm worried about the small guys who are trying to compete. They should be able to know what the playing field is in a way that they can meaningfully compete. And likewise, agencies, to the extent possible, should consider, do we have a good reason for this? The act of articulating reasons is a forceful reminder to avoid arbitrariness or worse. So waiver is useful and inevitable, but should be safeguarded to prevent its abuse, and that is the paper.
Thanks, Aaron. So our second speaker is Virginia Seitz. She's a partner at Sidley Austin's Appellate and Litigation Practices, where she returned after 2 years of leading the Justice Department's Office of Legal Counsel, the first woman confirmed to that position. Through a 25-year career of advising clients and arguing cases, including her successful 2006 oral argument before the Supreme Court, she's well earned her reputation as one of the nation's leading constitutional lawyers, and so we're very fortunate to have you here today. Virginia, thank you.
Sure. So I have a personal reason to thank you for inviting me to the Antonin Scalia Law School, which is that my husband, Roy McLeese, clerked for Justice Scalia his final year at the D.C. Circuit and his first year on the Supreme Court, and we met there because I was simultaneously clerking for Judge Edwards and Justice Brennan. And when Judge Edwards would go down with one of his frequent knee injuries, I would replace him as Justice Scalia's squash partner. And the justice told me when I was nominated for the OLC job that heading OLC was his favorite all-time job, perhaps a slight exaggeration. But not surprisingly, my views on discretionary non-enforcement were shaped in significant part by my time at OLC, though it's certainly not irrelevant that I've been married to now former federal prosecutor for 30 years. Aaron's paper describes the numerous ways the executive exercises non-enforcement discretion, from express statutory conferral of waiver and suspension power, to express delegations of interpretive and priority setting power, to implicit delegations through a congressional failure to appropriate the funds necessary for full enforcement. Aaron's paper provides support for a plea made by both him and by Zach's scholarship. The legality of non-enforcement policies has to be assessed at a micro level. Exercising a congressionally authorized waiver authority pursuant to regulation is not legally controversial, but granting the president line item veto authority, not so much. In between, there's a lengthy, nuanced spectrum of ways that agencies set priorities and make decisions that results in under-enforcement. How do we start thinking about that spectrum? Contrary to the general view that OLC is full of eggheads, after reviewing a statute and the policy, we generally would start by looking at practice. We would try to find the founders' views on a question and translate them to the administrative state. We'd think about and look at established executive branch practice and see the reality that under and non-enforcement are everywhere in the administrative state, that there is a resource constraint that is everywhere. That fact is not changing. Congress's eyes are always bigger than its stomach, and OLC would find that fact highly legally relevant. But when you don't trust agencies or have a constitutional framework that objects to broad delegations of authority to the executive to make law, you're going to look hard for some kind of check on this incredible discretionary non-enforcement power. It's salt in an already gaping wound of excessive congressional delegation. And this is particularly problematic for those who believe clear notice of what the law is important, and that consequences for its violation must also be noticed, or there are fundamental due process problems. But as Zach says in his articles, courts aren't generally in the business of examining non-enforcement. And when they get tempted, they try to find a statutory basis for doing so. For example, they turn a policy about non-enforcement into a rule so they can review it under the Administrative Procedure Act, as the Court of Appeals did in the recent DAPA immigration case. And OLC doesn't generally feel constrained by the absence of judicially manageable standards, but it isn't very likely to find clear limits on executive power when no judicially manageable standards exist. So it's very hard to find help from courts or OLC in evaluating this long-standing practice. For years, though, we've muddled along without any kind of constitutional crisis. So what happened? In my view, the current controversy about non-enforcement is really not about non-enforcement at all. It's about announcing policies of non-enforcement for political gain. The primary differences between discretionary non-enforcement of DACA and DAPA and the run-of-the-mind cases in Aaron's paper are publication and politics. Priority setting of this sort is unlikely to get more than a shrug in a prosaic setting, but immigration, of course, is politically charged. The text of the DACA and DAPA policies is clear. The guidance is not binding. The consideration is case by case, etc. But the president had an incentive to make these policies look like rules, as did his opponents. Is that kind of presidential talking legally relevant? That's certainly a hot issue these days. Let's take transparency first and political hot buttons second. First, I don't believe political administration should be legally punished for being transparent about enforcement priorities and practices. Guided discretion is better than sloppy discretion. Uncertainty about enforcement may be a deterrent to violators. We've all read the experiments that show this is true. If a pigeon pecks and gets food, it keeps pecking. But if it pecks and sometimes gets food and sometimes doesn't, it still keeps pecking. So uncertainty does breed compliance. But if the price for deterrence is unfairness and arbitrariness that an absence of priorities represents, I'll take certainty. Randomness works, but it doesn't feel like law or good government. So speaking publicly about how you, an agency, will choose to allocate enforcement resources can also let others know, other institutional actors know, what you're doing so they can exercise their own constitutional powers. They can provide more enforcement resources or enact specific priorities or spending. These public allocations also let the public know who is accountable for non-enforcement. If finding standards to assess non-enforcement is not realistic, then transparency may be our best hope for a check on non-enforcement. Don't we want to know if the executive has a policy to not to pursue nonviolent white-collar offenders for RICO violations, just for example? Announcing non-enforcement in a world where significant non-enforcement is inevitable is a public good. And the fact that an administration has showed its cards shouldn't convert a priority-setting policy that expressly preserves case-by-case discretion into a take-care violation. With respect to politics, how comfortable are we going to be saying that a priority-setting policy that requires case-by-case decisions really isn't that, based on politicians' words? If the DACA policy were de facto or in an internal deliberative document, would anybody think courts should be able to infer a take-care violation by observing a pattern of non-enforcement? On the one hand, I don't believe the fact that the president acts for political reasons should change the legal analysis. Penalizing the president for seeking political gain is like penalizing a firefighter for putting out a fire. On the other hand, inherent in the notion of law is notice. So one thing that makes law law is talking about it, and a president's speech has a constitutional status of its own. Isn't he telling the executive branch that what seems like a policy is really a rule? So to the extent he says that a policy is in fact a rule, is that legally relevant? In other areas, now, we're about to see new law on the legal relevance of presidential speech, I think. There are limits to non-enforcement policy, but they likely flow from the particulars of the statute, the policy, the language, appropriations, etc., that surround a particular law. OLC articulated some limits in connection with DAPA, for example. But whatever limits there are should not be a function of the transparency of non-enforcement policy or of whether the president is using non-enforcement for political gain. And I fear that is where the law is trending today.
Thank you. Our third speaker, our last speaker, is Zachary Price. He teaches and writes on constitutional law and civil procedure at the University of California, Hastings College of Law. Before that, he was a lawyer at the Justice Department's Office of Legal Counsel, if I'm correct, serving for part of that time with Virginia. His 2014 article, Enforcement Discretion and Executive Duty, is one of the best things you'll ever read on this crucial subject. And I want to reiterate this, and it's a point that Aaron made. I remember when some of these lawsuits were being filed a couple of years ago challenging aspects of non-enforcement in the previous administration, and the only paper out there, the paper that everybody would go read over and over again, was Zach. So I hope you were right.
For better or worse, yeah.
And I welcome you here today. Thank you very much.
Well, thanks very much. Thanks for the generous introduction. Let me just first of all thank Adam and Leah for organizing this wonderful conference. It's really an honor to be here and get to comment on Aaron's paper, and a particular pleasure to have a reunion with Virginia, who is my old boss, as Adam was saying. So it's probably a good indication that she may be right and I'm wrong on any points of disagreement. But just start with a brief word about Aaron's paper. I think it's a really great contribution in the way it gives us a better picture of how agencies are using non-enforcement authority and offering some thoughtful perspective on ways to address potential concerns. As he mentioned, I think what I'm going to do in my time is take a more theoretical, big picture perspective. So I've written about non-enforcement as more of a general separation of powers problem, where the key question, as Virginia was alluding to, is really how far presidents and other executive officials can go in stripping force from laws they dislike and not enforcing laws they dislike. Is this an open-ended power to license violations or invite violations because they disagree with the law on policy grounds, or there are some limits we can articulate on that authority? So I thought I'd use my time to try and offer my basic perspective on those broader background questions, and we can circle back to the particular administrative context Aaron was looking at. I think one thing maybe to start with is, Aaron highlighted the way in which this is sort of leapt to prominence, and it's certainly not a new thing. This is a recurrent separation of powers problem in a lot of ways across American history. But it's become particularly salient during the Obama administration. We had the federal government announcing these dramatic policies with respect to marijuana and immigration. Now the shoe is on the other foot, and we've got liberals complaining, crying foul over Trump's approach to Affordable Care Act enforcement, environmental enforcement, among other things. And so is there some reason for this? I think there, could just be a function of the personalities involved, but I think there's reason to think there are some structural forces at work that are going to make this a continuing feature of our political life. Of course, for one thing, as you all know, we're operating in an environment of increasing partisan division, in particular polarization within Congress. I think that makes legislating more difficult, generally reduces Congress's capacity to deal with problems, which in turn places more political pressure on presidents to take action on their own in various ways. At the same time, another feature of the environment at this point in history is that there's just a lot of federal law at this point. There's a lot of law prohibiting a lot of behavior, at least nominally, and particularly in the criminal law, but also I think in immigration, other areas, a lot of it's actually designed to be harsh, to give the government leverage. And then in that context, we all seem to think some of this law is out of date, but have pretty strong disagreements about which laws those are. And so in that context, this fundamentally negative choice to abstain from enforcing particular laws or stripping force from them, it's basically deregulatory choice, can be a potentially important form of policy decision. So basically, we've got a lot of law, we've got political contestation over the merits of existing law, congressional gridlock stymieing legislative solutions. And I think it's that in that environment that we see enforcement in these politically salient contexts becoming really attractive and potentially quite significant. So it's in that spirit that I think it's important to try and think through what limits there might be. And so to turn to those questions, I think there are really three separate issues that we have to think about. One is just the primary question I started with of the nature of the executive obligation, if there is one. But then secondly, and somewhat distinct, I think, is what role courts can play in enforcing that obligation. And then finally, the problem of reliance that kind of the tax hypo raises, or what do we do with regulated parties who act based on executive assurances? So to start with the basic question of executive obligation, my own basic view, which I'm happy to elaborate more, is that we should not think of enforcement discretion as a kind of plenary executive power to do whatever executive officials want. And in particular, crucially, it's not an authority to change the content of substantive legal obligations. I think the constitutional separation of legislative executive power properly implies some degree of discretion. In particular, supports presuming at least case-by-case discretion when you're administering some general statute. But the constitutional provision most on point, right, the Take Care Clause, doesn't authorize legal cancellation. On the contrary, it requires the president to ensure faithful execution of the law. So I think that the basic background constitutional structure cashes out in presuming some degree of discretion, a kind of case-by-case power to moderate the law in application, but not an authority to make broad categorical exceptions that undermine the policy of the statute. Now, part of the reason this is hard is that in a lot of areas of modern regulation, particularly criminal law and immigration, I think fits this picture also, there's just such a mismatch between what the law says and the resources available for enforcing it that sort of tidy structure is going to break down to some degree. But I think even there, the really key limiting principle is to maintain that the enforcement discretion is a power to allocate resources. It's a power to pursue one case rather than another because the government doesn't have the capacity to pursue both. It's not an authority to change the law or do things that are functionally equivalent by inviting widespread disregard for it. So from that point of view, to turn to the kind of key examples from the Obama years, I think the Affordable Care Act delays were clearly unlawful within this framework without some more specific delegation of authority. It's not permissible to just wipe away the effect of a statute. On the other hand, I think the marijuana policy was perhaps dubious but defensible insofar it was articulated entirely in priority-setting terms, a very non-committal way. And this is, in some ways the hardest question. I think the immigration policies, DACA and DAPA, also crossed an important line. And it's not just that they were transparent. The marijuana policy was transparent also, although I am kind of skeptical about transparency as a good practice, and we can debate that. But I think the really key feature of the deferred action programs is the way they invited large subsets of regulated parties to apply for an unusually determinate form of enforcement relief, and one that moreover carried certain legal consequences for work authorization, among other things. So, but anyway, that's the way I think about the general problem of enforcement discretion. I should also say these are all more conventional separation of powers contexts. I think the agency context is a little more complicated in the way that agencies have so much interpretive discretion over the primary legal violations, but I think you do end up with basically the same principles being applicable with respect to legislative rules in that context. But anyway, to move on to the second question, if I'm right so far about the executive obligation, then the next question is, well, what role, if any, can courts play in enforcing that? And what happens if someone breaches their obligation to give effect to statutes? And so I do think the judicial role here is limited, but I think it's really important to understand why. I've argued we should think about this executive obligation as a kind of political question in the sense of the political question doctrine. This actually circles back to some points earlier in the day. A court reviewing an enforcement policy is in much the same position as a court looking at whether there's a non-delegation violation. There's just not a very clear law-like principled way to say that you're picking the right priorities or even making the best effort at all. It also would involve courts in a kind of managerial function with respect to agencies that generally thought to be beyond their purview. So for that reason, I think this obligation I'm describing is judicially under-enforced for institutional reasons. But importantly, that's not always true. And in particular, courts do have an important role to play in enforcing the most important limitation on enforcement discretion, which is that it's not a power to change the content of the legal obligations themselves. And courts have done that, as was mentioned earlier, and they've overturned the unlawful suspension of some Obama-era legislative rules in the environmental context. I think this is also the right way to think about what the Fifth Circuit did with the DAPA program, if you buy my view that went beyond normal enforcement discretion. And the key feature there is that the court can simply, by nullifying the policy, can restore the deterrent underlying effect of the primary substantive law itself. So that's at least an important way in which courts can limit use of enforcement discretion. So that's executive obligation, judicial review. I think the last problem, in some ways, they're all difficult, but a really tricky one is the problem of reliance, right? So what happens if regulated parties in practice rely on some policy of forbearance, even though it may be notionally non-binding, but then a new sheriff comes to town who wants to overturn that policy? Can they assert any kind of defense based on their detrimental reliance? And this is the position, essentially, that deferred action beneficiaries and, to a lesser degree, marijuana businesses around the country are really in right now. And I think, ultimately, although this view can be quite harsh in practice, in general, I think the general answer has to be that neither due process nor the APA can properly protect that kind of reliance. And importantly, that's not because that result is particularly fair or reasonable from the perspective of regulated parties. And I have argued there are some limited ways in which courts can mitigate the resulting unfairness. But I think in general, courts can't protect reliance because doing so would eliminate that central limit on non-enforcement authority that I started with, right? If executive officials could invite reliance on assurances of forbearance, then executive officials could effectively wipe away prohibitions and acquire that power to change the law that enforcement discretion alone can't give them. And so this issue is actually a somewhat live question coming up in some of the DACA repeal litigation. And I think on this question, as with all these issues, it's important to keep in mind the general trans-substantive character of this problem. So to my mind, the litigants in those cases, the DACA beneficiaries, are extremely sympathetic, but it's not hard to imagine the Trump administration adopting policies in any number of areas, from environmental law to gun control, ethics, you name it, that could encourage unlawful behavior by regulated parties that a subsequent administration might want to reverse. And I think courts need to keep that broader perspective in mind. But with that, I'll stop there, and I really look forward to the discussion.
I have a couple of questions of my own. I do want to turn it over to the audience pretty quickly, but before we get into any of that, do any of the speakers have any comments on what we heard so far?
It was great.
Let's just end on that. Everybody go home. So we're talking about enforcement of the laws, and Virginia, I think you already identified one distinction you could draw. Some statutes that expressly afford, waiver power, and some that don't. But another distinction that I think is worth drawing is between different types of law more generally, right? Statutes, judicial, or judgments, or regulations, right? I'm wondering if any of you thought about how the considerations that might govern executive or agency non-enforcement of any of those areas of law might differ. I mean, just jotting down notes, I was thinking, in Federal 78, Hamilton talks about how the courts would be checked in part by their reliance on the executive branch to enforce or not enforce. I think in Federalist 47, maybe 74, Madison and Hamilton talk about, and I think, Zach, you're alluding to this, right? That you separate the legislative power from the executive power so that then the executive can sort of temper the legislative power in part through non-enforcement. And then even, I was thinking about regulations. obviously not in the Federalist Papers per se, but you look at Section 706 of the APA, and Congress talks about judicial review of agency action unreasonably withheld, right? Which implies that action reasonably withheld is okay, right? And so I'm just wondering, I'm belaboring the point now, what we're talking about now, should it differ, our considerations differ based on what type of law we're talking about?
Well, Zach has a paper where he talks about a spectrum of different kinds of laws, and I think he acknowledges, and I think Aaron's paper picks this up, that statutorily conferred discretionary authority, particularly when it comes along with standards, is the strongest case for constitutional discretionary enforcement, because you'd have the added layer of protection from the APA. If you're not complying with the standards for waiver, it's arbitrary and capricious, and so those seem to me like easy cases. I know Zach took it on as, in one of his articles, as somebody was saying, no, even statutorily conferred, congressionally conferred discretion in these areas could be considered unconstitutional under take care. I mean, I'm just not buying that. So maybe you're a better person, Zach, to answer that question than I am.
Yeah, no, I agree entirely with that. I think that the problem that I'm describing, I think, is a feature of having. It's a separation of powers problem if you have a statute that's just a general restriction on private parties that's officially enforced without any express power of waiver conferred. I think conferring waiver authority is constitutionally permissible, and I think if you have a statutory grant of waiver power, then a lot of the general administrative principles about consistency and clarity and so forth can pretty easily come into play. I think that the puzzle of enforcement is that how to think about this problem of having some restriction that an agency is bound to enforce on some level but can't enforce completely, and so how should it go about that task? In terms of some of the other things you mentioned, I think the difference with legislative rules is again, a lot of the administrative context, the kind of background difference between that kind of stylized separation of powers picture I'm presenting is that the agency has, or is understood to have, interpretive authority over what that statute means. And so that can require a different analysis in some contexts. Sometimes agencies will describe things as enforcement policies when what they're really doing is interpreting the substantive content of the law. And I think that's what's really at play in some of the other cases that were talked about earlier, like the Encino Motors and those decisions. But I do think if the agency cashes out that understanding in a legislative rule, then, the idea of a legislative rule is that it binds regulated parties, it has the force and effect of law, and so I think you should probably have the same basic norm that the agency should be either enforcing it or trying to change the substantive rule as best it can. Court judgments, I then think, just get at questions of departmentalism and sort of how to understand that. I think at this point we have a very strong and valuable norm that the executive branch abides by court judgments, even if it disagrees with them, and I certainly wouldn't want to see that.
Tomorrow's always a new day. You never know.
Yes, right.
One important thing from OLC's point of view that sometimes gets neglected here is the language of appropriations laws. They're separate from statutory schemes. We would often see fairly detailed instructions in appropriations bills or restrictions, and sometimes even orders that use the word shall that require spending in certain areas. And so it's an additional area of guided discretion when appropriations bills are so detailed about how the money should be spent and what money is available and what can and can't be spent. And then we consider it telling when there aren't such signals in appropriations bills, because often there are, and we contrast those situations. So I think when you're looking for clues about what the restrictions are on discretion in an and you're the lawyer in the executive branch, and you don't see any such clues in appropriations law, that's a significant signal to you.
So I hesitate to throw this out here because it's still in the very, very early stages. But it seems to me that there's an interesting question about agencies that waive their own regulations And that is, if you've been paying attention to the Seminole Rock debate, which is the idea that it's dangerous to allow agencies to get deference when they interpret their own regulations, on the theory, contested to be sure, on the theory that it encourages them to write vaguely because then they can get deference later on. Well, if you buy that argument, then it seems to me that there is a special danger when it comes to agencies waiving their own regulations. Why? Because it encourages them to regulate broadly, knowing that they have a release valve for when they want to use it. I don't know how you'd enforce that. You could get rid of Seminole Rock deference or something like that, but it wouldn't solve that problem to the extent that that is a problem. I don't know empirically if that's real or not. It's just still early stages thoughts. But it seems to me that to the extent one buys the Seminole Rock critique, it might have some teeth when it comes to regulations as well.
And then just one more question from me, because we have, in particular, some agency officials in the audience today. I'd be curious, and all of you have, practice advising clients, so you're used to boiling things down. If there's one or two sort of best practices you could offer agency folks in the audience as they are tasked with thinking through their own use of enforcement discretion. Just what's the best possible advice you could give people? I know it's a very broad question, but any kind of concrete advice you could give folks in the audience under existing law would be, I think, useful.
See, I thought you were going to say the opposite. I thought you were going to say if they have any real-world things at work, what are they doing? That'd be very useful for us as well. I mean, I guess my answer would be realize the dangers, realize the benefits, but remember the dangers are there. And if you find yourself doing this a lot, to the extent that it's within your power, see if you can change the regulation. I don't know if there's pains in doing that because it's not so easy just to change the regulation. But boy, I'm old-fashioned, but I like to think that one should be able to look at the law on the books and have an accurate sense for what the law is. And to the extent that there's divergence between what's happening and what the law on the book says, I think that that's problematic.
I agree with that, but a lot of the times when we confronted this situation at Justice, it was because the problem was with the statute rather than a regulation, and the possibility of Congress actually moving in to correct something like that was almost non-existent. And so then what I would say is, non-enforcement discretion is not unlimited, and it has to be, you have to have the safety valve of an ability to make case-by-case exceptions to even whatever discretionary guidelines you decide to set based on resource constraints. And so, always write a policy that you mean, and always talk about the policy in the way that you intend to enforce it, meaning that you retain case-by-case discretion, that there are exceptions even to discretionary non-enforcement guidelines, and be honest, treat it as guidance rather than a rule, because if you walk down the road of treating it like a rule, then it causes the reliance unfairness that Zach mentioned, and it's also potentially constitutionally problematic. So it has to not be a rule. It has to be guided discretion of the sort Justice Roberts praised in his Duke Law Review article about the Administrative Procedure Act.
So I actually agree with both of those. I don't have much to add. I think that, the balance that I think actually a lot of agencies probably get right in practice is between, taking seriously your responsibility to carry out statutes, whether you particularly agree with them or not, but at the same time, you don't have to throw the book at every violator. It's important to, send the appropriate, exercise discretion appropriately, send the right signals to regulated parties to take their responsibilities seriously, but you don't have to, that doesn't, it doesn't mean you have to throw the book at everyone for every violation. But I do also agree with Aaron's point. I think, non-enforcement is, it's a necessary safety valve in a lot of areas. I think federal marijuana law is a great example. It sort of seems like an appealing form of executive power because you have laws like a federal marijuana prohibition that most people don't think is really appropriate, and so it it provides a way of releasing people from that sort of outdated or unnecessary law. But it's actually, I think, a fundamentally unattractive way of solving problems, because it creates all these puzzles we're dealing with about what does Congress really intend. It can weaken the pressure on Congress or the agency to actually address the problem if people aren't burdened by the law because of non-enforcement. But then it leaves people then vulnerable to enforcement, even though there may not actually be democratic support anymore for the law that's on the books in place. So I just echo what Aaron said in the agency context. I mean, agencies can more easily solve this problem by rethinking as they go whether if they really should be putting into the regulation some more explicit exception.
All right, well, with that, if anybody in the audience has a question, we'll go ahead. Let's start right there, and then Bill over here on the left.
Hi, my name's Elaine Mittleman, attorney in private practice, and I had Judge Edwards as a law professor right before he became a judge, so he's a great guy. Two real quick questions. One is I have been working on a case involving HUD, Community Development Block Grant Funds, and I've asked HUD bajillion times to do some oversight, and there's HUD regulations, and I don't think they enforce them at all. And secondly, or at least in a lot of cases they don't. The Inspector General may do a report later. Second question, I was wondering, Aaron, if you discuss at all Don Blankenship conviction relating to the federal mine safety laws, because he was convicted of conspiracy to violate them. So I don't know if that was a unfair enforcement or not. I have no idea, but I just didn't know if you addressed that.
I will answer that part. I have no idea. I didn't look at that, didn't come up.
I think you've stumped the panel.
I mean, on the non-enforcement of HUD, it's kind of interesting, right? I assume that what you're describing as non-enforcement is not anywhere written in a policy. And so then the question is, can you infer from a pattern, a violation of a take care authority? And I think that presents kind of an interesting question that I don't think anybody has looked at. I'm confident OLC would think you couldn't do that. I'm reasonably confident courts would think that that's a pretty hard set of discovery to allow in order to infer that there's been a take care violation. I think the most interesting question really would be how Zach would feel about that.
I mean, in terms of remedies, I mean, certainly doctrinally, I think that's right. I mean, the Heckler, the case mentioned earlier, excludes at least case-specific non-enforcement decisions from judicial review. It does hold open the possibility of judicial review of what it calls abdication, if the agency has completely abdicated enforcing some statute, and then it gets cited a DC Circuit case dealing with kind of complete non-enforcement of civil rights laws in the education department, I think. But there's very few cases applying that principle, because it gives rise to then the next question is, well, what abdication as to what, right? Agencies probably abdicate enforcing particular regulations all the time because they always have something better to do in terms of how they perceive their enforcement priorities. So I think, call your congressman, right?
Speaking as a litigator, the discovery seems impossible.
Okay,
So real quick, here's a word that law professors use that I hate, and I'm sure that you don't like either, under-theorized. But some of this is under-theorized because it hasn't come up a lot, and so there's still a lot of things that we're thinking would be very valuable, like the pattern point. I don't think there is such a case on that. I don't think there's a law review article on that. I don't know what. Maybe if it is, Zach wrote it.
But once the Supreme Court puts out a question for briefing about the take care clause, I think you immediately have to think about the spectrum of ways you would enforce that obligation.
Correct.
And so, unless you have a policy statement like you have in the immigration case, which I submit if you read carefully is not is just, as it says, case by case, says discretion. I think you then have to think about how would you prove a violation of take care where no one's admitting it.
Yep.
Bill, and then the next question will be here in the second row.
So I think the panel is excellent in breaking apart different types of non-enforcement. And just as you were speaking, sometimes the conversation went from thinking about a president or agency's roles that are often only the president's or the agency's to take, and then slid into talking about regulations. But actually, I think there's a difference with regulations that this needs to be factored in, which is lots of regulatory standards are enforceable privately by state, set standards for behavior that become parts of transactions, may even be applied in negligence settings. And so they're really standards for conduct that would live on even if the government itself stepped back from enforcement. And so I think just when an agency says seemingly an innocuous, similar non-enforcement, we're going to suspend our review of this regulation or suspend the regulation, that's suspending it for everyone. And I just think that's quite different than something that's solely the government. So I'm not sure how it plays out, but I just think we somehow the conversation was equating them when I think they're quite different, and at least in a way that should be different as you think about the appropriate.
And that's a really important point with respect to why this has emerged as an issue, because if you look at marijuana non-enforcement and the immigration laws, there's no potential for private enforcement there, right? And so that's part of why they present the issue they do.
Well, but that's Oklahoma and what was the other one? Kansas, Nebraska, one of those two. They tried their own version, really, of private enforcement. Right now, of course, it failed, so maybe it proves your point.
I think it does.
But
Again, so one thing there is actually on the broader theoretical question, I think that the Congress's power to enable private enforcement or set up different incentive arrangements for agencies is part of the evidence I find persuasive that we shouldn't actually think of this as an inherent feature of executive authority. I mean, it's sort of a function of particular institutional contexts, and particularly criminal law seems to drive the way a lot of people think about this, but I think even there it's really developed historically more through a kind of accretion of prohibitions that are without resources to enforce them. And I think Nick Burrell was here, has written about the salary revolution that really enabled that shift in a lot of ways. But I think the very fact that Congress can create possibilities for private enforcement or key TAM enforcement suggests that we should think about this more as a kind of function of legislative context than some kind of inherent executive power.
great. So here, and then are there any other questions? Then the last one will be in the back.
Hi, David Wagner. I was just wondering whether it's ever come up in the cases, or more likely in the literature, that maybe we should apply to agencies the rules we apply to presidents. Now, I understand that there's a good reason why, as a matter of law under the APA, the president himself is not an agency. There's some problems with that. But I'm thinking about Clinton v. New York. I mean, has the argument ever been made that when an agency enforces or does not enforce a statute, it's enforcing what it is enforcing is something that Congress never passed, didn't go through the Article 1, Section 7 process, and therefore is a charter violation. That will be the majority holding over a dissent by the two admin law professors on the court, that this is just an ordinary non-delegation problem, like a zillion others that we've declined to enforce.
I guess my first reaction to that is it's not two sides of a coin. Non-enforcement is seen as inherently extremely different than enforcement. And so I think, I haven't really thought through your question, but I would think you'd have to start from a different place constitutionally as you thought about non-enforcement, not as if it were a law. But
I think, well, go ahead.
I was just going to say, that's when we say under-theorized. That's the word that we use.
I mean, I think Clinton would be the best modern case for the view that delegated waiver authority is unconstitutional, but I think that's the wrong way to read the case. I think it's really all about canceling specific provisions right after the law is passed. I don't think it should be understood to call into doubt a kind of ongoing authority to waive particular statutory restrictions over time.
And then last question.
Does discretion ever trump retroactivity concerns? So let's say the statute delegates to the agency, you have discretion to administer this program or to, whatever, what have you. And so the agency, as a matter of policy, decides not to enforce a certain provision or using its discretion decides not to enforce something. And then a new administration comes and chooses to enforce. So people who took actions based on the non-enforcement policy reasonably relied on it to their detriment. At what point does the agency's absolute discretion in an area trump, I guess, taking away certain benefits or enforcing certain action?
So we have to fight your premise a little bit. Reasonably relied is the premise of your question, and Zach's point, I think, is in an area where an agency is just exercising non-enforcement discretion and continuing to retain case-by-case ability to differ, there cannot be reasonable reliance. And the anguish of the dreamers today, I think, is a very good illustration of the fact that he's right.
So I mean, to add to that, I do think that's true. But I think that to go back to the kind of depressing political dynamics in the background is I think generally what has happened historically is that as a practical matter, we don't have legal protection. We can't have legal protection because that would violate these limits that I'm talking about. But we kind of rely on the political process or as a practical matter, if someone relied on a enforcement policy promulgated in good faith, then they're not going to be the agency folks can correct me, but I would imagine the agency would be disinclined to then turn around and enforce the statute of regulation against them. But when we start seeing these things in really politically contested areas in a high-profile way, I think it elevates the risk that that sort of political protection will break down, unfortunately.
Okay. Well, before we thank our panel, I want to thank all of you here for taking the time to being here. I know you're all very busy, especially this time of year, and so to carve out an entire day to join us is something that we really appreciate here at the center. If you're interested in the work we're doing here at the center, interested in future events, and you're not already on our mailing list, then please visit our website, administrativestate.gmu.edu, where you can sign up for more information. Like I said, the next public conference will be in late January on the First Amendment, particularly free speech. Administrative agencies. We're very excited about the papers and speakers we have lined up for that. So until then, of course, Happy New Year, but also please join me in thanking our speakers today.